State Aid in Challenging Times, and the popularity of this event is testament to our speakers' preeminence in their respective fields. First, we have Professor Suzanne Rab of Serle Court. Suzanne is barrister, member of the Inn, and is now also visiting professor at Imperial College Business School. It's fair to say that Suzanne is the doyenne of the competition law bar. Quite apart from her busy practice in competition law and related areas, Suzanne somehow finds the time to author a host of important texts in a number of fields of law, and also to share her wisdom in lectures such as this. Suzanne's going to discuss current issues which reveal the stresses and strains in the state aid system, not merely those presented most recently by the COVID crisis, but also the equally fundamental and continuing problems arising from Brexit and the nature of the subsidy control regime at the end of the transitional period, if indeed it is ever going to end. Now, we're also fortunate to have James Rivett QC of Pump Court Tax Chambers. James took silk last year, but very much remains the poster boy of the tax bar, with a stellar reputation across all areas of tax, from complex corporate and direct tax to VAT and even duties. And he will be known to many of you as a fearsome opponent when acting for the revenue, but has a very rare and enviable quality when acting for the taxpayer, namely the ability to win. Now, James is going to pick up on a number of themes to be raised by Suzanne, and in particular, specific issues arising in competition law before COVID, namely the overlap and interface between state aid and taxation. Suzanne's going to begin this seminar, but before doing so, as Emma has already mentioned, both speakers have very kindly and possibly rashly agreed to take questions. If you use that chat function, I will then sift through them and filter the questions for later. Now, given that you are here to listen to Suzanne and James, and that my role as compere is entirely ornamental, I propose to turn off my video so that my Martin Sheen in lockdown impression is not too distracting, but I will re-emerge if need be to referee between the speakers and also to deal with questions at the end. So with that introduction, if I may, I invite Suzanne to take the floor.
Thank you very much, David, for that introduction. Quite a lot to live up to. I will do my best to do so. It's fair to say at the outset that we did have a plan in February to organise an event around the interplay between state aid and Brexit. And obviously events took over, and we found ourselves in March in the position that the world is in now with the outbreak of coronavirus, which rather made some of our plans seem to be quite second order. But we are here today, and the title of this presentation is State Aid in Challenging Times, if there ever was such an understatement. So that will be the brief of my presentation this evening, to focus on the stresses on the state aid system that have been brought to the fore in the context of dealing with the coronavirus, and also looking ahead to the UK's future state aid regime. I do have a backdrop in terms of slides, which will pop up behind me. So I'm just going to take a few moments now to share my screen with you all, and hopefully the technology will not fail us, and very shortly you will see the backdrop to my presentation. So the overview is to look at state aid and coronavirus, to cast a glance and a forward-looking view to what would be the UK's approach to subsidy control after Brexit, and then to look at potential scenarios in the event that there is no trade deal. secured between the United Kingdom and the European Union when the transition period ends at the end of this year. I'm very pleased to see from the participant grouping that we do have a very wide audience with us this evening, both geographically and also from a cross-disciplinary perspective. And we will try very much to share thoughts that are of interest to everybody. But I do recognise that we have some real state aid gurus in the room, and others who may not be as familiar with this area. So please forgive me if I may have assumed too much or not enough knowledge, but I will do my best in terms of the foundational area. But essentially, what are we concerned with state aid? We're concerned with the EU regime, which makes unlawful any financial assistance, economic assistance on a selective basis, which confers an advantage on particular undertakings and sectors where that threatens to distort competition. That, in a nutshell, is the overlay of the state aid framework in very basic terms. And unless state aid is notified to and approved in advance by the European Commission or benefits from an exemption, it is unlawful. So the framework is a challenging one and quite specific to the EU regime. As we have seen with the outbreak of the pandemic, that has forced governments around the world, not just in the European Union, but in other countries, to embark on various measures, fiscal stimulus measures, and other programs which are aimed to address the economic consequences of dealing with the public health emergency. And here is a snapshot of a few initiatives way back in March, shortly after the announcement of the more stringent lockdown measures in the United Kingdom, which gives an overview of the EU significance and much further afield. That is obviously something that is moving in real time, and the real question from a state aid perspective is how can this procedural framework operate in real time and with agility to address this very pressing need for dealing with the economic as well as the health emergency on an immediate and longer term basis, but also recognizing that decisions may be taken which can have knock-on consequences down the line. The first State Aid Commission decision that was taken happened rather early in early March, and this was approved in a 24-hour period, a measure for a Danish scheme to compensate that damage caused by cancellation of large events due to the outbreak of the pandemic. And what is interesting about this decision is the speed at which it was put into place, when normally individual notifications would take at least a month, potentially longer, even at the first stage. It's interesting that the Commission used a provision under the treaty which allows member states to compensate specific companies or sectors due to damage caused by exceptional occurrences. So the pandemic was not treated as a natural disaster, which would have benefited from a blanket exemption under a legal tool called the General Block Exemption Regulation. And it's that what made an individual notification necessary in this case. But looking at that 24-hour period, certainly those who were practicing in state aid law during the 2008 crisis will recall similar speed at which measures were put in place to deal with some of the bailouts at the time, Bradford and Bingley, for example. So this is by no means unprecedented, but shows how the EU machinery was adapting to the immediate issue. And I'll put a placeholder there to ask whether the UK's own subsidy control regime, due to take effect at the end of the year, would be in a position to respond with similar agility in the circumstances, had it been the relevant body to whom notifications would be needed. Very shortly after that measure, the Commission adopted a temporary framework to support measures on a much wider basis without the need for individual notifications. So what we would expect in terms of direct grants, advance payments, subsidised public loans. And again, some resemblance between this approach and what was done in the financial crisis. This has since been updated, and I would expect that this is certainly not the last word that has ever been said on this issue. So is there anything special about dealing with the pandemic from a state aid perspective that might cause us to think differently when it comes to this pandemic, contrasting the experience in 2008? Well, just as at that time, there have been calls for a complete suspension of the state aid rules for this purpose. For example, the Austrian government has called for that. So far, those pleas have been resisted. Similar pleas were made, as I say, in 2008. The arguments that have been put in support of that have been that delays in EU procedures may contribute to further economic crisis simply because the machinery will not turn fast enough. That similar argument was made in 2008 and was not accepted as a reason to completely jettison this area of regulation. So we're working within a framework of individual notification or benefiting from the temporary framework as it continues to evolve, and in relation to a variety of different measures. It is fair to say that a number of sectors are very much in the eye of the storm, and the areas that have very obviously been hit by the turbulence include the aviation sector and hospitality and retail, where social distancing and other measures are being relaxed in varying degrees, but certainly longer term issues in those sectors are coming to the fore. So while some schemes have been approved, allowing for tax deferral, this is by no means a carte blanche for every and each measure that supports the aviation sector, the airline industry, to benefit from public funding. And even before the pandemic, with the collapse of major household names such as Flybe, state aid in the aviation sector was very much a high priority issue. So inevitably, this issue will continue to run, with many different sectors arguing for treatment which would ordinarily be looked at under state aid rules. So this brings us to the question of Brexit, and certainly this is a topic that I have been speaking about for it's almost 4 years now, and again, some of the themes are quite recurrent, others are evolving. So before the pandemic hit, the prognosis was that one could expect Brexit not to translate into necessarily higher levels of public support to businesses in the United Kingdom, at least judging by historic levels, which all seems rather academic given the situation we are in right now. So the framework that will take place at the end of the year is modelled around there being a new independent subsidy control authority, and the CMA, the Competition and Markets Authority, so our domestic competition regulator, is due to take over the role currently performed by the European Commission. So at one level, this seems to be a continuity of a form of state aid regulation. And for those of us who have practiced in this area for some time, certainly we will not be hanging up our coats right now. But we've certainly seen this area evolve to quite considerable extent over the years. So very much in the backwater, when I started practice 20 years ago, state aid was injected almost with a new energy with a number of tax cases over the last 3 years, which James will reflect on later in this presentation. So there are still some very wide and interesting issues quite apart from Brexit, and a very interesting scenario where it's fair to say that the anticipated role for the Competition and Markets Authority is quite unprecedented. Here I have to disclose an interest. I have been supporting the CMA on capacity building for some time now, in terms of putting in place the machinery and the legal understanding on this area. But as those closer to this will know, there is a dedicated unit at the CMA with a variety of skill sets drawing from law, finance and economics to be ready to go should it be necessary. And that has been the position at least until the earliest get-go point at the end of March last year, but that has been progressively extended, and now we're looking at the end of this year. But what will that framework look like in the multiple scenarios that are now becoming increasingly narrow? And the one which is being focused on right now is of the UK leaving the EU or benefiting from a transition period, as it were, without there being a deal on trade between the UK and the EU. And the default position there is a framework where WTO, World Trade Organization rules would still apply. Now, the WTO rules do contain a control regime on subsidies, which I will map out the essentials very shortly. But ultimately, we have provision for a framework very similar to the EU framework, with necessary modifications to make that operate in a domestic context, regardless of any future trade deal. The exact scope of that is still something on which the detail will be worked out, but there is certainly a framework there for something that is WTO plus and modelled on an EU regime. How much the UK will depart from that and over what time frame is one of the more questionable aspects and one of the exciting aspects from a business perspective and in terms of legal development. So broadly, to sum up, the extent to which EU state aid rules as we know them will apply in relations with the EU will depend on very much what future trade deal is struck, if any, between the UK and the EU. And given the positions that have been expressed certainly by the EU, their anticipation is that state aid provisions will feature in some way, but that remains a matter of some debate and controversy. I did say that this is a relatively unprecedented area. It is fair to say that there are third countries, of which we will be treated as one, that have subsidy control regimes: Ukraine, Serbia, Macedonia. But what these have in common is that they are candidate countries or aspirant members of the European Union in a full sense, which is certainly for now the converse of the situation we're presented with in the current climate. So the potential scenarios that are being discussed in relation to state aid. So the transition period is until the end of the year. Hopes were held out, certainly for those who were thinking of more time, that there may be an extension, but that is pretty much off the table now. We are looking at different scenarios. The protocol for Northern Ireland focuses on the position in the devolved nations, which is a whole topic in itself that I don't propose to go into in great detail, but certainly has been an area where there have been quite different views from an England perspective, the Westminster Parliament and the devolved administrations on just how much autonomy would be given in this area. But certainly where Northern Ireland is concerned, with the latest arrangements, we have a modified form of a backstop arrangement where, in very broad terms, as regards the position of Northern Ireland, there is at least a 4-year period where trade flows will be governed by very much EU rules if there is not a new relationship agreed. So then the scenario of a UK departure from the EU at the end of the transition period without a new agreement on trade is the one increasingly being focused on. How much that will borrow from WTO inspired principles, how much it will be similar to the EU model is the one on the table. And some of you may detect something of a policy schizophrenia there, which says, well, what advantage is there in having anything that is enhanced above WTO rules given this moving target? But certainly the rationale behind that has been the sending of a message overseas that the UK is very much open for business, that concerns around protectionism, about an open market where there are equal opportunities for investment, where the UK can attract investment and is seen as offering something which is over and above the default position, is certainly been the rationale of preserving that. At the same time, recognizing that the closer alignment to the EU that can be achieved would typically translate into greater access to the single market. So as I've mentioned, the European Commission continues to be competent for state aid notification procedures this side of the end of the year, but after that the relevant body will be the CMA, who will also be the relevant decision maker on individual notifications. And I have been asked, well, should we be talking to both authorities depending on when the procedure needs to be gone through, bearing in mind that there will be proposals, there will be initiatives underway right now which do not ideally sit either side of the end of the year. And certainly in the area of competition law and merger control, those overlap cases require a very careful handling at a diplomatic and regulatory level because of these ongoing interests. So looking at those future models, so as mentioned, broadly 3 systems have been considered. I've mentioned parallel systems where there are examples in other free trade type arrangements and association agreements. Some of the context of those arrangements may seem quite removed from the United Kingdom, where issues regarding political instability, avoidance perhaps of notification, and questions of enforcement may have a significance in some of those states which are not necessarily the same in a regime which may be considered perhaps more transparent than some other examples. So there are instances that we can compare in third countries, but certainly not necessarily comparing like for like. Even looking at WTO type models, building on the WTO agreement, and examples there being Canada type deals and deals struck with South Korea and Japan. So there is certainly some frameworks, but their geographic proximity to the European Union does rather present an interesting point of comparison, which has certainly been used as a differentiator. So to summarise this state of play on that future relationship, so the EU's position as declared in March was very much seeing the Court of Justice as the sole arbiter of EU law and seeing strong and enforceable level playing field commitments. That seems to be somewhat removed from the UK stated position, and looking at zero tariffs and zero quotas, but specifically when it comes to state aid, the protections there are somewhat weaker than the declared negotiating position of the EU. When we are looking at Northern Ireland, again, to try to give as many real-time updates as I possibly can in the constraints of this short session, the House of Lords has certainly expressed some reservations on how the protocol interacts between various other measures, and it's by no means clear on how 2 parallel regimes might be retained, with Northern Ireland being part of both a customs union and a customs territory. So looking at the mechanics of how that might work in principle, and I have no pride of authorship over this very stylized diagram where there is some attempt here to try to understand what appears to be the position in trying to preserve the position of Northern Ireland without having a physical border on the island of Ireland. The idea that there would be no tariffs passing from GB to Northern Ireland, and similarly the Republic to Northern Ireland itself. But when it comes to state aid, there is a question of how can that segmentation be so rigidly maintained. For example, if an advantage is given to a UK headquartered entity which has operations in Northern Ireland, what does this actually mean? Is that a GB NI trade flow? Is this the business of the EU or the UK? How much needs to be demonstrated from a tariff perspective in collecting duties about the likelihood of there being any consequential trade flows into the European Union, which for practical purposes would usually be the Republic of Ireland. Will we have to fill in forms to claim retrospective rebates on any duties paid or not paid, and what will be the level of burden on business from an administrative perspective? So that detail is something which remains to be worked out, and has certainly been expressed some concern on the part of trade lawyers as well as state aid lawyers. So contrasting state aid with WTO rules, and there are many similar concepts here in both regimes, which to those with perhaps a more passing experience of this area may seem some similarities, and ask, well, how different really is this? Under the WTO agreement, a subsidy is a financial contribution granted by a government which confers a benefit targeted at certain enterprises or industries. So some very similar concepts, albeit perhaps less case law and guidance on how these are interpreted. But a main difference is that whereas the EU state aid rules cover both goods and services, the WTO regime is confined to the area of goods. There's a distinction between prohibitive and actionable subsidies, where we see under the WTO regime that there are certain complaints about subsidies which are handled on a more expeditious basis, but others that are not prohibited outright are generally permitted but actionable, which is in quite contradistinction to the EU regime, where we have an ex-ante notification obligation in the absence of any exemption or framework in operation to effectively suspend that and render it unlawful unless there is an approval. So quite a different procedural dynamic and risk call. Countervailing duties, again, are a tax imposed on imports of the subsidised goods, which makes them more expensive to buy. And this is another way in which enforcement is achieved, allowing states to take measures where subsidies are hurting their domestic industry. So to try to summarise some of the details, and again, this is perhaps a topic much wider than we have time for today, and in terms of the default position, the scope of the rules and the application. But perhaps one takeaway that I would like to leave you with is around who can take action. Because under state aid rules, businesses, individuals can lodge complaints, and there are procedures at national level which can bring about a remedial solution, essentially under the WTO rules, which has been highlighted as one of its obstacles and challenges and differentiators, is that it is the states themselves rather than private actors who take the initiative. And a lot of the recovery mechanisms have been held up as one of the more problematic areas of the WTO rules. So I'm reminded of an experience I had at passing Parliament Square with a demonstrator holding up a placard saying WTO rules okay, on the basis that we will be all right just with a WTO type framework. Well, I think it's important that we do understand exactly what those rules are, and certainly there are quite differing perspectives on whether they are fit for purpose, and that is a continuing debate. So to leave you with some tentative conclusions before I hand over to James, we've certainly seen how the business as usual that we were operating under, at least in the early part of the year, has been put into quite a different frame of reference in light of COVID-19, and really puts stresses on the state aid system. But up to now, the Commission has responded in ways which have been predictable, but evolving to some extent. We've seen a very sharp impact in certain sectors which continue to be beneficiaries, or at least are arguing for special treatment, and that debate will continue and make this a very active area, whether we call it state aid, whether we call it subsidies, whether we call it financial stimulus or something else. The avowed negotiating position of the UK has been to depart from EU state aid rules post-Brexit, but ultimately the devil will be in the detail, a lot of which still remains to be worked out. We've seen that historically the UK has granted comparatively limited state aid compared to some member states, Germany, France and Ireland being examples. We've seen that recently in the tax area that there has been quite a UK significance, which James will touch on. And interestingly, the UK has argued for a much more open and equal treatment of third countries in this area. So it will be interesting to see how that plays out when really we will be very much a third country as negotiations continue. So one thing I can say in a world of uncertainty is that one thing we can be certain of is certainly for the next few years, this area will continue to be characterized by some uncertainty, and where we do end up will be a mix of political drivers as much as the UK's future relationship with the EU and other trading partners. I will conclude my comments here, and I will stop sharing my screen with you all. Thank you very much for your time. I will now hand over to James.
Good afternoon, everyone. I hope you can hear me. I'm going to share my screen as well. My slides are rather less exciting, I'm afraid, than Suzanne's, but I thought it would be useful to have the references on here. Just for those of you that are worrying, I undertake to make sure that I have got through my material in time to ensure that the ice does not melt in your 6 o'clock cocktails. And really what I'm here for is from the perspective of a tax practitioner, not essentially a state aid practitioner, to comment on the way in which state aid issues impact upon the shape, structure, and practice of tax law in the UK. To set that in context, I want to have a little look at the past, then to have a look at some current state aid issues in the context of tax, and then to have a look at some of the difficulties that may arise in the future. So first thing first, what's the relevance of state aid to the questions of UK tax? Well, when the government wants to change the behaviour of its subjects, it has a number, or the Crown subjects, a number of means of doing it. It can make the behaviour prohibited or mandatory. It can give direct financial assistance to encourage the behaviour, or it can use the tax code, either to advantage a particular action or to disadvantage that action. Anything which goes beyond that is really just a question of advertising. And since, in particular, the days of our original membership of the EU, we've had a partially harmonised tax code insofar as VAT and various indirect taxes have been harmonised. But what is increasingly been the case over the last 30 years has been the development of the impact of wider measures from an EU perspective into the direct tax realm, in which the member state is typically or essentially intended to be autonomous, save insofar as the actions of the member state offend one or other of the fundamental freedoms, or for today's purposes, can be identified as constituted prohibited state aid. Interestingly, one of the points that's made by Conor Quigley is that if you look at the list of state aid cases that have been heard over the years, as much of all, at some points, 40% of all state aid is related to fiscal measures introduced by one or other member state and their government. So its impact on tax practitioners is significant. And one of the other themes that's been the case is that through the development of the jurisprudence over the last few years, you have seen an increasing tendency, perhaps in recent times in particular, to see an element of activism on the part of the Commission of using state aid as a means of, not necessarily a means of advancing a political agenda, but actually as impacting upon the way in which national state tax regime operate. And you see that through a comment that Suzanne made, but actually there's been an increasing spate of legislation in recent years in the corporate tax sphere in particular. Initially, tax cases that concerned state aid were focused upon fairly obvious examples. One of the earliest examples was the Italian example of a tax exemption that was conferred upon various Italian textile undertakings. But more recently, the challenges have become more sophisticated, both direct challenges to exemptions, but also oblique challenges to the failure properly to police domestic tax laws, which in themselves were unoffensive from a state of aid perspective, but through the inaction of the member state in enforcing them were less so. One of the particular areas that I want to touch upon when it comes to look at the future is a point that's foreshadowed in some of the most obvious examples of state aid that have been examined through the courts over previous years by the JEU, notably the German case involving East Berlin, where an exemption provided a particular narrow exemption provided an exemption for the promotion of investment in East Berlin, which was found to amount to state aid. We've seen similar challenges made in the context of the Apple litigation and earlier challenges as well to certain aspects of the Irish tax regime. So that's my way of backdrop. And it's highly relevant because all of those observations about the trajectory of state aid's impact upon the way in which our UK tax code is crafted and enforced become relevant, obviously, once one understands a bit about how the EU context is going to impact upon our domestic code going forwards. So the present, well, on the 31st of January 2020, the UK left the EU, as we all know. And as Suzanne has pointed out, the terms of the withdrawal agreement are such that the entirety of the UK remains subject to state aid rules until the 31st of December 2020, while in Northern Ireland, the rules will apply until at least 31st of December 2024. During the current transitional period, the state aid will apply to the UK And the Commission and the Court of Justice were made competent to deal with state aid granted before that point. So our historic issues, particularly things like the CFC litigation that's ongoing, remain very much in Europe. Those trips to Europe have not ended yet. But going forwards, there will be this tension that Suzanne has identified between the operations that fall within the ambit of the Commission and the European institutions and those which fall within the CMA, which has been set up over the last 2 years and is raring to go. From a technical perspective, leaving aside the as it were, international aspects of state aid's impact upon the UK tax code, there's also a whole load of issues that remain so far unexplored in relation to how it is that recovery proceedings are issued in a domestic sphere under the existing arrangements. These are being worked out quite interestingly in the context of the CFC litigation at the moment. As those of you who are involved in it know, the Commission issued its decision back in April last year, which required recovery by the UK within 4 months of the date of that decision. To date, what's happened has been actually relatively limited by HMRC, who issued a paper at the end of last year indicating that they were proposing to recover the state aid that the Commission had identified there through a mixture of 3 or 4 possible means. First of all, through the administration of the tax code, through closure notices, inquiries. Second, through discovery assessments issued against taxpayers to disgorge the benefits. Third, possibly through voluntary contractual arrangements. Those voluntary contractual arrangements are not quite what they seem. In those circumstances, what HMRC means is that there is a carrot mechanism, effectively, whereby in the event that you voluntarily return the relief that you've received, you'll have access to other corresponding reliefs that may not otherwise be available to you, and there'll be arrangements put in place to deal with those. Quite how that will work, I think, is a point that's bothering a great deal of practitioners at the moment. And the fourth and final mechanism, which I think to a number of us seems to be the obvious mechanism by which to deal with recovery, is legislation. But interestingly, HMRC have specifically to date ruled out the possibility of legislation to deal with the disgorgement, albeit reserving their position to ability to legislate in due course to deal with this. But by far the more interesting aspect of the impact upon of state aid practice upon a tax practitioner and upon tax work is, of course, the future. One might think, as I said, that the effect of having left the European Union was that for future purposes, the EU rules on state aid would not be of any relevance to the shaping or enforcement of issues that arise from a UK, in relation to the UK direct tax code. That, unfortunately, is wrong for a number of reasons. The first is that whilst the political declaration, which formed part of the withdrawal agreement, stated in express terms the need to ensure a level playing field for open and fair competition, and emphasised the intention of the parties to uphold the common high standards applicable in the Union at the end of the transitional period in the areas of state aid, competition, social and employment standards, environment, climate change, and relevant tax matters. Quite what effects that political declaration has remains to be seen. It was, interestingly, text that was originally enshrined within the terms of the agreement itself, but was then removed to the political declaration, and then shortly after it had been delivered, undermined by the comments of the Prime Minister that were made in January this year, which made pretty clear that the UK did not intend to align with the bloc's rules. The difficulty then arises from the point that Suzanne has touched upon, and which actually is, I commend to anybody listening, is touched upon and dealt with very interestingly in an article by George Peretz and Alfred Artley in the Tax Journal of May. I'm sure all of you have a copy of the May Tax Journal next to your beds, but if you don't, you should do so. And they raise this point, that under the terms of the Northern Ireland agreement, protocol agreement, the effect of the agreement that's been reached to date is that, in essence, the Commission will be not only the policeman of the Northern Ireland state aid regime, which will continue to be the EU one. But the difficulty there lies not simply in terms of the conflict of systems that Suzanne has identified, i.e. the territorial war, if it be such, between compliance with the requirements of the CMA and the requirements of the Commission, but from a legislative perspective, in ensuring that Westminster does not obliquely engage something which is offensive to an EU state aid issue by virtue of the Northern Irish Agreement. Let me give you an example of that. As we know, as matters stand, the number of devolved taxes are actually relatively few. But the intention is that those will increase, notably in Northern Ireland in particular. The intention has always been to devolve corporation tax. But imagine the situation in which Westminster passes a general tax measure that benefits UK engineering. In the event that there were Northern Irish engineering firms that were affected by the measure, which was on the face of matters subject to offended an EU principle of state aid, then the policing of that would be subject to a challenge by the Commission under the terms of the protocol. But even if there were no Northern Ireland engineers, an unlikely event, but even if there were none who were affected by it, in the event that a Scottish or Welsh manufacturer sold their subsidised engineering product into the Northern Irish market, then that would place, or might place, the Northern Irish industries at a competitive advantage to their counterparts in Scotland and Wales, and which would itself engage the watchful eye of the Commission, even though the measure had nothing to do with Northern Ireland, on the face of it, with Northern Irish engineering. And as I say, there's an interesting article on that in the Tax Journal this month. An additional point to make in relation to that is actually also the point that apologies, my phone rang. The internal market from a UK GB perspective in relation to that, in circumstances where there are devolved taxes in relation to this, i.e. the competing difficulties that the CMA is going to have at managing the requirements of Edinburgh with Westminster, where there is a collision of interests in relation to state aid. And you can imagine that quite easily when you come to look at the cases from the German experience of the East Berlin operation and just transplant that to, for example, a Scottish measure that favoured Glaswegian land. And finally, in this regard, the interesting development today that the Commission itself has introduced a white paper proposing and discussing a new instrument that would allow the EU to take account of foreign subsidies, i.e. non-member state, which we will in due course be or are now, which go beyond the existing anti-dumping and other trade anti-subsidy subsidy rules, and to redress them. And one of the areas that the Commission has specifically identified as being a category of foreign subsidies which is considered likely to distort the internal market is operating subsidies in the form of tax reliefs outside general measures. In this regard, the Commission has noted that the principal remedy for state aid infringements which now exists, i.e. Activity by the Commission, may not be feasible in circumstances where you're dealing with a third country, and has outlined a list of possible redressive measures, including divestment of assets, prohibition of certain investments, and of specific market linked to foreign subsidy, and redressive payments to the EU or member states. Now, it looks like the principal motivating concern on the part of the Commission on this white paper is China. But in particular, in the absence of circumstances where if there's no deal and the UK agrees to operate a state aid regime, it may be that UK companies wishing to trade in or operate in the UK are forced to divest themselves of the advantages of, for example, an exemption to the CFC regime in order to avoid being prohibited from the EU market. So the fact that we have left the EU does not spell the end of our requirement to keep a close eye on developments in Europe, because they will still affect us, both directly if the white paper takes effect, but also indirectly, directly through the white paper, also through the Northern Irish Protocol, but also indirectly through our obligations under the Northern Irish Protocol to adhere to them. I've just unfortunately gone past 6, but I think that's the point at which to hand back to David Scorey, who has got some questions, or may have some questions.
Thank you very much, James and Suzanne, for that. It's very interesting. We have questions, I'm pleased to say. The most popular question is one that, if you'll forgive me, I'm going to answer, which is the attendees are clamouring for copies of your slides. And I understand that you're more than willing to email them to the relevant individuals. And I've taken the liberty on the chat function of emailing everybody your email addresses. So if they want those slides, they can obtain them from you. The next question is one initially for Suzanne, and it's this. If there is no agreement, Suzanne, with the European Union at the end of the transitional period on trade matters, what happens to matters currently being examined by the